What up? What up? Yeah, it's pretty funny when I say that, I guess. I don't know. Maybe you think it's pretty stupid. You're like, "Ugh, I wish I could fast forward through the first 5 seconds of this video. Fortunately, on Ed Puzzle, I usually allow you fast forward, but I think on these, I'm not going to allow you to fast forward, so you have to listen to it, which is pretty much an LOL moment. Anyways, the Supreme Court. El Supreme Corto. Uh, Pretty much my favorite aspect of government. I don't know why it is. I think just because, you have nine justices, nine people who can overturn the will of an entire state, many states, thousands of people, elected officials who are making decisions on what public policy is. And it is really a tremendous hallmark on our democratic system. And again, I will emphasize this throughout this unit. The Bill of Rights was put into the Constitution to protect the minority interests, meaning individuals who may have a view on policy that is very, very unaccepted by the vast majority of Americans. And that, again, is a hallmark of our system. You can have um, beliefs that are not very popular, but they're protected. And in other countries, that's not the case. But the Supreme Court ultimately determines and interprets whether or not the government has violated your rights, whether or not you have protections in the Constitution, even if they are not popular beliefs or practices that you have. Again, Article 3 of the Constitution establishes a Supreme Tribunal. Tribunal, that's such a cool term. A Supreme Tribunal, in this case, we call it the Supreme Court. That Supreme Court consists of 8 associate justices and 1 chief justice. And again, if you think back to Unit 1, which none of you want to do, but will have to do prior to the final exam, think of Federalist 78, which said that these justices will serve for life appointments on good behavior, so that they do not feel like they have to heed the majority opinion on a particular issue. So they can make unpopular decisions and not have any repercussions. And that is a key, again, to our democracy. Um, Again, judicial review, we talked about that in regards to Marbury versus Madison, which is the first Supreme Court case that really establishes the ability of the Supreme Court to interpret whether or not something violates the Constitution. That case, although boring, dry, is essential in our history. And without that decision, where they interpreted a piece of legislation, in that case, the Judiciary Act of 1789, we would not have the ability to interpret whether or not, for example, and I know I keep coming back to this case. The only reason I come back to it is because it's so historical and it's so recent. The gay marriage case that was determined this past summer. I mean, I don't know how many states had laws that define marriages between only a man and a woman. Um, and although times have changed in regards to gay rights, and we are, as a country, more accepting of equality in that regard, if you go back to when I first started teaching, which I won't tell you how many years ago, 15, um, that was not the case. The majority of Americans would not agree with the right of 2 men or 2 women to get married. So the Supreme Court has a lot of power in regards to judicial review. And again, as I talked about in a previous screencast, a lot of times pieces of legislation are very broad. They're not very clear. So the Supreme Court and even the lower courts kind of define those pieces of legislation. And when we talk about Obamacare, for example, is another significant Supreme Court decisions, meaning there's been several cases dealing with aspects of that piece of legislation. The court decides whether or not Congress, in this case, has passed a law that is unconstitutional. Again, I talked also the last screencast, the ability to overturn previous Supreme Court cases. This should be italicized. I'm a big proponent One of my pet peeves is not italicizing Supreme Court decisions. So Brown versus Board, which eliminated what Plessy said, which was separate but equal. Brown versus Board said separate but equal is inherently unequal. And so this case overturned this case. Again, the Supreme Court and even the lower courts rarely will overturn previous decisions because it doesn't look good if our court system is constantly overturning other decisions. Jurisdiction, the Supreme Court has original jurisdiction, meaning they hear the case first, whenever you have states against each other. A previous case, which I believe was 2 years ago, dealt with Colorado, Nebraska, and I believe Kansas. And there was a river, doesn't really matter what river, that flowed through each of those states. And they had an agreement which said that each state could take a percentage of that water. Well, one of the states disagreed with the other two states and claimed that they were taking more water than they should. So that case was heard for the first time at the Supreme Court level. So there are some cases where the Supreme Court hears original jurisdiction or hears the case for the first time. The vast majority of the cases, however, are appellate, meaning they're heard on appeal, either from state Supreme Courts, Illinois State Supreme Court, or from the Court of Appeals, those 12 circuit courts of appeals. I would say probably 98% of the cases are heard on an appellate basis or on appeals. So they have very few cases that they're going to accept that our original jurisdiction are only heard by the Supreme Court. Let me see here. Let's go back real quickly to the selection of justices, and we'll kind of look at one of my favorite websites in the history of mankind, which is Oyez. At the beginning of each session of the court, some doofus goes, Oyez, Oyez. It's not Oyez. It's Oyez, Oyez. And that begins a session. But anyways, there's very few specifications on the selection of justices. As you know, the president will appoint a justice, but it is approved by the Senate. And this has become a very political process, specifically over the last 30 or 40 years as we've become more partisan at a national level between the Republicans and the Democrats. But you see here, this is a list of the justices. This is a phenomenal site. I just cannot tell you how often I will go to this site almost on a daily basis. It makes me a VIP. But Elena Kagan is the most... hello, Elena. Elena Kagan is the most recent appointee by President Obama and approved by the Senate. There, again, you would assume that most of the justices have been a judge at a lower level previous to being nominated by the president. Elena Kagan was not a justice prior to becoming a Supreme Court justice. If you look at her little biography here, she was a dean of, I believe, Stanford. Let's see here. Who cares? She was a dean of... Now it's going to bother me. It's too much of a biography here. But she was never a judge, which you might argue, and some did, that she was not qualified to be a judge. However, she was confirmed. She was the Solicitor General of the United States prior to becoming a judge. The Solicitor General is an individual when the United States government is a party to a Supreme Court case who will argue on behalf of the United States. You need to know that position. It's called the Solicitor General. And so they will argue in front of the Supreme Court, and sometimes they have assistants, whenever the United States is a party to a Supreme Court case. And we'll look at some cases in a second. If you look here, it gives you a little biography, gives you some cases that were argued where she made a decision. So that's Elena Kagan. Hello, Elena. Sonia Sotomayor. Hello, Sonia. The first Hispanic justice, is that historic? Yeah, I suppose so. She did have a background. She was a circuit Court of Appeals judge prior to becoming or being nominated by President Obama to be a Supreme Court justice. And I mean, we could go down the list. Some judges are older than, Ruth Bader. Well, hello there, Ruth. She's got a little York Duke earrings on today. She is like 4'5". I mean, she's probably the shortest Supreme Court justice in the history of the court. But Ruth Bader is one of my favorites. She has battled cancer 2 or 3 times. She is, I believe, the oldest justice. We'll see here in a second. A justice that is extremely important is Anthony Kennedy. And as we talked about the gay rights cases, especially the gay marriage case this summer, he is one of the justices. Where's his picture? Why doesn't he get a picture? Ooh, libertarian individual freedoms. Anthony Kennedy is what we call the swing justice on the court. So there are 4 very conservative justices and 4 very liberal justices. He tends to be in the middle. And on some of the fiscal or business or monetary issues, he tends to side with the conservatives. On the libertarian issues like freedom to marry someone of the same gender, he is consistently sided with the liberal justices. So oftentimes when a court case is close, they're going to look to Anthony Kennedy to determine, or predict how the court will go. There's, on some of the key issues, 5-4 decisions, and he is going to be the key justice in that case. So when you talk about a justice who's a VIP, Anthony Kennedy. This site also has a tour of the Supreme Court, which is pretty awesome. If it loads. You can see the justices' chambers, where they work. Oh, that's pretty majestic. What do we got going on there? What is that? Book collection. Who cares about some dumb old books? What do we got here? A rocking chair from a former justice. This is the worst chamber ever. Let's look at our VIP Kennedy. Oh, now there's a chamber. What do we got here? The heck is he kissing the horse? Looks like he's kissing the horse. That's a little creepy. Let's see what's going on in Kennedy's chamber. A globe. What a boring chamber. My classroom would make a pretty good chamber. There's a lot going on there. John Paul Stevens was actually from Chicago. Now that's a chamber. Little scales. Oh, no. Lady Justice. What's going on with her hair? It's a bizarre lady. I don't know who that is. What's over here? What? What is that? World Series book? Oh, boy! Michael Jordan, your favorite Chicago Bull, 23. John Paul Stevens has retired. Again, justices can serve as long as they want, but they can step down. And he was a pretty awesome justice because he wore a bow tie. He was very famous for wearing a bow tie and is actually from the Chicago area. So anyways, the courtroom, the justices literally sit in front of you, and the Chief Justice is in the middle, and you come up to the lectern and you make your argument. And they can interrupt you at all times or any time, and we'll look at that a little bit later. But OEA is a great website, just phenomenal website. And you can look at some of the oral arguments. And as you can see, these are all during the 14-15 season. I guess it's not really a season. But Obergefell versus Hodges is a gay marriage case. And we could listen to the oral argument. This is a great website.
We'll hear argument this morning in case number 14-556, Obergefell versus
See how
Hodges,
it makes
and the consolidated cases.
the person light up?
Mr. Chief Justice, and may it please the court, the intimate and committed relationships of same-sex couples, just like those of heterosexual couples, provide mutual support and are the foundation of family life in our society. Yet the legal commitment, responsibility, and protection that is marriage is off limits to gay people as a class. The stain of unworthiness that follows on individuals and families contravenes the basic constitutional commitment to equal dignity. Indeed, the abiding purpose of the 14th Amendment is to preclude relegating classes of persons to second-tier status. What do you do with the Windsor case where the court stressed the federal government's historic deference to states when it comes to matters of domestic relations? States do have primacy.
So again, the justices can interrupt and ask clarifying questions, and they do that frequently. What you'll see here is there's an hour and a half of argument in this case, extremely rare. Very, 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 very rarely do they allow more than 30 minutes. So both sides gets 30 minutes to argue their particular stance on the case. Because of the historic nature of this case, they extended it. They actually had 2 days of oral arguments. There are two aspects of this case, which we'll go into probably next week. But an hour and a half of oral argument is extremely, extremely rare. And again, the justices can chime in whenever they want. Clarence Thomas is unique. He hasn't talked but one time in, I think, 9 years during cases being argued in front of the court. He just sits and listens. Others ask questions frequently. The Godfather, Scalia, Ruth Bader, the Chief Justice, John Roberts, tend to ask more questions. But they can chime in whenever they want and ask questions for clarification on a case. So it's not like you see in Judge Judy or Law and Order. It's one individual making their argument in front of the court, and the Chief Justice and the other associate justices can ask questions during this entire time. So again, the justices, there are no specific qualifications in the Constitution, but most of them are old. Most of them are experienced in the courts at a lower level, not necessarily all of them, and they tend to be relatively moderate. As you need the Senate to confirm. So you can't have a super conservative or a super liberal justice. How do cases reach the Supreme Court? Well, a petitioner, so the individual who lost at the lower level, may petition the court to take their case. This is where we get into what we call a writ of certiorari, which is an agreement to hear the case. All you need is 4 of the 9 justices to agree to hear the case. It doesn't mean you're going to win, but you need 4. That's called the rule of 4. So you take writ of cert or certiorari and rule 4, and those concepts are definitely related. And so if 4 justices agree to hear, they have agreed to issue writs of cert or writs of certiorari. From a technical standpoint, what that means, and this is very important, so you should be writing this down, it means they have asked the lower courts to send up all the records of the case because they are going to hear it. That is what a writ of cert means from a technical standpoint. From a practical standpoint, it just means they're hearing the case. They've agreed to hear the case. It doesn't mean they're going to rule on the case. They could send the case back down after hearing the case. So in the Raisin case, the first time that was brought before them, they listened to it, and then they sent it back down to the lower levels with instructions. Another vocab term, this is called a remand, R-E-M-A-N-D. They're remanding the case to the lower levels, usually with instructions, meaning we made a decision in this case. Look at the case that we're sending back to you and consider what we decided in a similar case. That's often what they will do. The Raisin case is unique because it ended up a few years later, ending up back at the Supreme Court, and then they did make a decision after the lower courts considered what they previously told them to consider on remand. So remand means you're sending it back down to the lower courts after you've heard it or looked at the case. How does the Supreme Court work practically? Well, the term begins in October, the beginning of October, so it's relatively new, the present term, 15-16 term. Right now, there's probably about 40 cases on the docket, and they only hear a few cases during the week. So if we go to their official website, we can see their schedule here. So for December, this week they're hearing only on 2 days. So if we click on Tuesday, which is today, but now yesterday, they heard 2 cases. Today, they're going to hear 1 case. Friday is what we call the conference. A conference day is when they look at previous cases that they've heard, so the 3 cases they've heard this week, and they sit in a room and they kind of talk about where each of the justices stand on the case. If they feel they've decided the case as individual justices, they will go ahead and hand out who will be writing the opinion, and I'll get into that in a second. So you see in December, there's only 5 days of oral argument. On the 7th, they hear 2 days. The 8th, they hear, not 2 days, 2 cases. And the 9th, they hear a case, which is one of the biggest of this term, which deals with considering race when admitting individuals to college. We'll talk about this case next week. In these other days, so non-argument days like the 14th, what they're going to do on the 14th is determine which cases they're going to accept for the remainder of the term, which will go into, usually the arguments will go into May, and then decisions will result throughout the term. They don't tell you when they're going to release a decision, so it's kind of, a surprise. They could release a decision on the 14th, and they could not release a decision on the 14th. They don't tell you when they're going to release a decision on a case. What I will tell you is this: the controversial cases, they save to the end of their term, which is the end of June. So it's kind of like the school year. You start in the fall, you learn things, you get your final exam grade in June. They save the big decisions till the end of their term in June. I don't know if they do that to make it, exciting or what, but that's what they do. So opinions are written by usually one person. The Chief Justice decides if he's in the majority, who writes the opinion. If it's a key case, he's probably going to write it, because that case could be later referenced in history. So he might want his name tied to it. One thing, going back. Amicus briefs, as we've previously covered, are friend of the court briefs, meaning individuals who are not part of the case but want a decision to go their way. So interest groups might file these amicus briefs to try to influence the justices. They don't have to read them. They're going to read the ones that are legitimate, but they don't necessarily have to read them. Now, back to the opinion writing. If the Chief Justice is in the majority, he will assign who will write the opinion for the majority of the court. Individuals who agree with the overall decision, for example, that 2 men or 2 women can get married, can write what is called a concurring opinion. It means you agree with the ultimate result of the case, but you may disagree with the rationale. So you may think there's a different component to the Constitution that validates the ability, in this case, of 2 men or 2 women to get married. So you agree that 2 men or 2 women can get married. Your rationale or reasoning for that might be different. So you might feel very strongly that you need to write an opinion that says, you know what, there's a different part of the Constitution that should guarantee this right. A dissenting opinion means you're in the minority, that you disagree with the majority opinion and you can write a dissent. Most judges who disagree with the majority will write a dissent. So when the decision is released, you might have the majority opinion, you might have some concurring opinion to agree with the overall view of the case, and then you might oftentimes have some dissenting opinions. It's not as complicated as it seems. How can you get around a Supreme Court decision? You can just choose not to follow it. Again, some states have decided not to issue marriage certificates to 2 men or 2 women. They said, what are you going to do? We're not going to issue it. We don't agree with this. It's then up to usually the executive branch of the federal government, the presidency, to enforce a Supreme Court decision. So let's go to Brown versus Board of Education. The court ruled that schools should be desegregated in the South. Southern states just disregarded that rule, and for many months, schools were still segregated. It wasn't until there was pressure put on the federal government to enforce this decision that it was actually enforced, and the National Guard was sent in, etc. So again, there are ways to get around Supreme Court decisions. Obviously, the best way is to amend the Constitution, although that's very difficult to do. And again, the voting blocks, there's 4 liberal justices, 4 conservative justices, and then 1 moderate or swing vote, which is Anthony Kennedy again. And last but not least, they're all really, really old, some older than others. Peace.